Good morning, Mr. Doman. Mr. Shopp, I will call the next case, which is People versus Deandre Austin. This is a 15-minute mini oral argument on the application. Mr. Doman, you may attempt to reserve some of that time. And if you are prepared, you may begin.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, Tim Doman on behalf of Deandre Austin. I have some brief prepared remarks, but I can pause at any time for questions. For the reasonable doubt issue, there are really three main points that I'd like to make that I think are key to why we should win on this issue. First, the trial court's off-script instructions misstated the reasonable doubt standard. And I think this is especially true of the "we do this all the time" phone a friend analogy, which was the climax of this extensive colloquy the trial court was conducting on the reasonable doubt standard. And more than 100 years ago, this court in People v. Albers held that the reasonable doubt standard cannot be compared to everyday decision-making. But that's exactly what the trial court in this case did. And this was not a passing remark by any means. This was a point of emphasis for the trial court. And the court was at obvious pains to ensure that the jurors subscribed to its view of the reasonable doubt standard. The second key point I'd like to make is that the jurors would have understood the trial court's improvised instructions as explaining the standard reasonable doubt instruction. At multiple points during its colloquy, the trial court read the standard instruction and suggested that its analogies and hypotheticals serve to illuminate the meaning behind the standard instruction, which leads to my third point, which is really just a corollary of my first and second, which is that the jury would have equated the standard instruction with the trial court's improvised instructions. So contrary to the prosecution's argument, simply repeating the standard instruction would not have remediated the damage done by the improper instructions. And I gave the hypothetical in my reply brief that suppose the trial court had read the standard instruction and then told the jury that what this means is that you just need to be 51% certain to convict, which would be an obvious misstatement of law. At that point, once the standard instruction has been tainted like that, simply repeating the standard instruction is not going to fix the problem. I think, in effect, the same thing happened here. The trial court gave bad instructions. It communicated to the jury that its bad instructions explain the standard instruction, and so repeating the standard instruction didn't help matters. So I think we've established plain error with respect to the trial court's reasonable doubt instructions. And I could pause now, or I can go on to felony murder.
Let's pause. Justice Clement.
No questions at this time.
Justice Cavanagh.
I just have one. I think the position that you're advocating would have us, or is most consistent, or have us agree or adopt Justice Viviano's dissent in Kane. Do we need to overrule Kane in order to agree, if we agree with you on that?
Not at all. The decision in Kane never reached the third prong of the plain error test, so nothing about Justice Viviano's decision in that case was inconsistent with Kane.
Okay, thank you.
Justice Welch.
No questions.
Justice Zahra.
Thank you. Is it not significant here that all this occurred during voir dire, and then once the jury is selected, they're put under oath, they hear the evidence, and then again, before the jury is charged, the court instructs, you will accept the laws I'm about to give it to you. You're the finder of fact. You'll accept these instructions as the law. And then the court goes through all of the instructions at the time just prior to deliberation and accurately gives the reasonable doubt instruction. Isn't that a significant point? This did not occur just before the jury went in to deliberate. There's quite a bit of time between the voir dire discussion, which, by the way, always, as you pointed out, included the proper instruction. And then they're given the oath, they promise to follow the law, and they're charged just before deliberation, and everything is accurate.
I think in a different fact pattern, that distinction might matter, but here, this was just such a point of emphasis for the trial court. And even in some of the cases I cited in my brief, it's pretty typical for this scenario to happen during voir dire. There are several cases that I cited where this happened during voir dire where the courts found reversible errors. So I think if this was a comment made in passing during voir dire and then correct instructions were given, I think that would certainly change things. But here, because of just the amount of time the court took, because of the emphasis, and because at several points the court was questioning jurors to make sure they agreed with her statements, I think the fact that this occurred during voir dire doesn't change the calculus.
Okay, thank you.
Justice Viviano,
No questions, thanks.
Justice Bernstein.
No questions, thank you.
Mr. Doman, you may continue or reserve, up to you.
I'll just briefly touch on felony murder. In People v. Gillis, the court adopted the res gestae principle to circumscribe the scope of the felony murder doctrine. The court looked at treatises and case law from around the country to glean that rule. Taking the same canvas approach here, the court should hold that the res gestae does not begin until an indictable attempt has been reached. And in this case, I don't think there's any dispute that the shooter had not committed attempted armed robbery at the time he shot the limousine driver. There may have been intent, there may have been preparation, but that's not enough. My only other point is that there also has to be a causal connection between the killing and the robbery. Here, though, the evidence showed that the killing was in response to an attack by the limousine driver, and it was not done as part of the armed robbery. So it's either under an outside the res gestae theory or a lack of causal connection theory, the evidence was not sufficient to support the felony murder conviction. Other than that, I'm happy to take any questions on felony murder now.
Thank you. Are there additional questions for Mr. Doman at this point? Would you like to reserve some time?
I'll reserve. Thank you.
You bet. Mr. Shopp.
Thank you. Good morning, Madam Chief Justice. May it please the court. My name is Joseph Shopp, P81256, appearing on behalf of the people. This case ultimately is about the level of respect that our legal system gives to trial juries. If this court affords adequate deference to the jury in this case, it will agree with the Court of Appeals that the jury was not, in fact, misled by the trial court's elaboration on the commonly understood phrase, reasonable doubt. As case law going back over a century makes clear, the phrase reasonable doubt is within the comprehension of all qualified jurors as they walk through the courthouse doors. Here, the jurors' understanding was in fact reinforced by the trial court's exhaustive recitation of the model definition of reasonable doubt. Accordingly, to whatever extent the trial court's other instructions may have been ambiguous, there is no reasonable likelihood that the jury, in fact, misapplied the reasonable doubt standard in reaching its verdict in this case. Moreover, if this court affords adequate deference to the jury, it will also not disturb the jury's factual finding that defendant murdered Devin Lowe in the course of committing larcenies against Lowe's 3 young patrons. As explained at length in People v. Gillis, there are 4 factors that are relevant to determining whether a murder occurred during the perpetration of a felony: time, place, causation, and continuity of action. Here, the existence of 3 of these 4 factors is undeniable. It's hard to imagine 2 crimes taking place closer in time or in distance than the 2 crimes here, and the trial testimony clearly established that defendant seamlessly transitioned from murder to larceny with no stops in between. And the final factor, causation, was also sufficiently proven to the jury. After all, common sense and everyday experience make clear that defendant behaved in a suspicious manner in the minutes and even potentially hours leading up to the murder. And this suspicious behavior, combined with defendant's decision not to murder Lowe until the moment Lowe threatened to discover his gun, and the immediacy of defendant's decision to commit larcenies right after he committed murder, all of this gives rise to a reasonable inference that defendant committed the murder in furtherance of the larcenies. So I would be happy to take the court's questions on any of these issues.
Thank you. Justice Clement.
Great, thank you. Good morning. What is your response to Mr. Doman's comments regarding the fact that there's whether or not there's evidence in the record supporting a conclusion that the defendant had the intent to rob before he murdered the defendant? And does that matter?
Thank you. Your Honor, I think there's quite a bit of evidence here that he had that intent. And I think, first of all, it's important to note that minimal circumstantial evidence is sufficient to prove state of mind. So that's kind of the overarching concern. But there's definitely evidence that he had intent to rob, going back all the way to when they were at the Deluxe Lounge together before they ever got into the limousine. The defendant knew that the driver of the limousine was intoxicated because he had sold him cocaine, according to Mr. Etchen's testimony. Just in general, the fact that he got into the limousine in the first place late at night with strangers is suspicious. He brought a gun with him and concealed it from the other people in the limousine. And the immediacy of his decision to rob is suspicious. If he, and I think you have to put yourself kind of in defendant's shoes here, he just committed a murder, which is obviously, a startling event. But his first instinct was not to flee the scene. His first instinct was, oh, I might as well rob these 3 kids of their jewelry. The fact that he made that decision so immediately points to the fact that he intended to do that robbery all along.
Justice Cavanagh?
Sorry, now I can. I couldn't unmute. Sorry. I don't have any questions.
Justice Welch?
Mr. Shopp, I just want to jump back to the jury instruction issue. You obviously noted the notion of reasonable doubt is sort of well ingrained in our DNA as far as what that means. Is there ever a time that a judge could cross a line with, giving the proper instruction, but then providing an example that is just not correct? I'm just wondering, in your opinion, could that line ever be crossed?
Yes. I think the example defendant gave in his reply brief where the judge says 51% is sufficient, that would be obviously clearly wrong. And that would overweigh the proper definition. But I think the important cases that I cited on this point are Cupp versus Naughton and Waddington versus Sarasad, which basically the United States Supreme Court there said it's not a question of whether the instructions could be misinterpreted, it's whether there's a reasonable likelihood that they were in fact misused. Here, as I mentioned in my opening, it's well established that jurors know what reasonable doubt means when they walk through the courthouse doors. That's why there's quite a bit of case law saying the court does not need to define the phrase at all. Here, the court then moved on to exhaustively read the proper definition of reasonable doubt. I believe it was 6 times that she read the modeled instruction. And to whatever extent the hypotheticals she gave were ambiguous, that's just what they were. They were ambiguous. She didn't give a direct, explicit misstatement of law. So I think the United States Supreme Court's statement in Kansas versus Carr that jurors don't read too much into jury instructions, they're not looking for secret hidden meanings within them, is important. What is the jury reasonably likely to have done here? Completely ignored their own knowledge of what reasonable doubt is, which was corroborated 6 times by the trial court in favor of some interpretation of the hypotheticals? Or is it more reasonably likely that they, in fact, applied the definition that they knew and that they heard exhaustively?
Thank you.
Justice Zahra?
Thank you. If we find that the jury instructions given here on reasonable doubt amounted to plain error, is defendant automatically entitled to reversal in a new trial?
No, Your Honor. I think there's 3 cases that say that's not the case in the case of an unpreserved error. There's Johnson versus United States, which dealt with it in the context of a missing element in the charge. Then there's People versus Vaughn in the context of a public trial violation, and People versus Kane in the context of a juror oath. In those cases, it was well established that the whole Carina's test needs to be satisfied by the defendant. And here, defendant cannot satisfy it, even if there was error in the instructions. And I think Vaughn, Johnson, and Kane all point out that prejudice is relevant to the 4th prong insofar as was there a serious likelihood of unfairness or damage to the public reputation of judicial proceedings. I believe it was Johnson that said that if cases are cases are reversed based on unpreserved error, regardless of their effect on the result, that bestirs public ridicule of the judicial system. Here, for all the reasons I stated in my brief, it's overwhelmingly obvious that defendant committed these crimes. The DNA test result is absolutely remarkable in its 37 octillion to 1 match of his DNA. And there's just no reasonable explanation for that fact, combined with the fact that 2 of the witnesses to the robbery ID'd Mr. Austin as the perpetrator.
I guess where I'm struggling is in People v. Allen, a 2002 case from our court. We said that a decision rendered on the basis of an erroneous definition of proof beyond a reasonable doubt results in an untrue or is not a true verdict within the meaning of the constitutional guarantee of jury trial. So would a defective reasonable doubt instruction alone satisfy that 4th prong of plain error review? Or as I think you're suggesting, is there some authority that would allow us to look at the other facts and circumstances about this case before we get there?
Yes, Your Honor. I think the cases, and it's Vaughn plus Kane, indicate that when considering the 4th prong of an unpreserved structural error, we kind of need to look at what are the goals of the structural error. Why is that particular thing, whether it's public trial, what have you, is important to our judicial system. Obviously, the beyond a reasonable doubt standard is important because it protects defendants who are innocent from being wrongfully convicted. So I think looking at the prejudice, looking at the evidence in the case is relevant to the goals of that particular structural concern of our system.
And what about the concern I raised with opposing counsel about the passage of time and the correct instruction at the time of deliberation? How should all that impact our analysis?
I think that is relevant. I would agree with defense counsel that it's not necessarily dispositive. If the trial court had said something clearly wrong, such as I mentioned earlier, 51% is sufficient, it would be hard to imagine the passage of time helping the jury to forget that. But these sort of folksy instructions that the trial court gave over a week before deliberation started, I think that's a difference in kind rather than a difference in degree.
Thank you.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
I guess my question is, as I've been listening very closely to this, I guess my question would be is that do you representing the people have concern over the way that this was handled or this was done? I mean, ultimately, like, if we were to write an opinion, how would you want this court to write an opinion based off of the record that's before us in terms of these analogies that were used?
Your Honor, I assume you're referring to the instructional issue.
Correct. Yeah, I apologize. Yeah. I mean, my question is because it's interesting because, honestly, I wrote an opinion several years back, Stevens, and it basically didn't get into this issue, but just in terms of, some of the kind of concerns that basically affect how the lower courts function and operate. And I guess the question here is, I wrote it was dealing with the issue of impartiality of judges. And now, again, that's not the issue that we necessarily have here, but I guess my question is, as the writer of Stevens, I'm just trying to think, in this situation, how would you craft an opinion to give guidance and direction to the lower courts based off of what happened here?
Your Honor, I think the best model, for lack of a better word, would be Victor versus Nebraska, which is the United States Supreme Court opinion. There, the court noted that there is some difficulty in articulating what reasonable doubt is. So if the court chooses not to define reasonable doubt at all, other than to just state that the standard is beyond reasonable doubt, that's fine. But it's also fine that the court try to define or eliminate the standard if they choose to, and then just that they can't do so in a manner that is reasonably likely to mislead the jury.
Okay, thank you.
Counsel, you have a couple of minutes you may use.
Your Honor, I think the 200 pages of briefing was sufficient here. So in summary, the people respectfully request the court deny leave or in the alternative, affirm the Court of Appeals. Thank you.
Thank you, counsel. Mr. Doman, you have some rebuttal time.
Thank you, Your Honor. Just to skip around a little bit, going back to felony murder, as I wrote in the brief, and as authorities have held, coincidence of time and place is not enough. There needs to be a causal connection. And I think it is fair to say that given how quickly the shooter moved from the killing to the robbery, that the jury could infer that the robbery was preconceived. We've never contested that. It's a different thing to say that the same facts support an inference beyond reasonable doubt that the shooter committed the killing to accomplish the robbery. Going to Justice Zahra's question about fulfilling the plain error standard, a bad reasonable doubt instruction, I think, is unique even among structural errors because of what the United States Supreme Court has said. When there's a bad reasonable doubt instruction, there's been no jury verdict in a constitutional sense. It vitiates all of the jury's findings. So I think we can fulfill plain error in that way. And going to one of the overarching things that opposing counsel has said about reasonable doubt being comprehensible to lay jurors, I think there's a difference between not defining reasonable doubt and defining it wrong. And I think I've offered the court scores of cases where trial courts have undertaken to define reasonable doubt. They've done it incorrectly, and the courts, including the United States Supreme Court, have found that requires a new trial, that the jury would have taken the judge at his or her word and would have used the standard given by the judge. The only final thing I want to say, and to keep on the reasonable doubt instructions, I think that is the most troubling part of this case. The right to be presumed innocent unless guilt is proven beyond a reasonable doubt is one of the cornerstones of American criminal justice. It's a right that doesn't apply in many parts of the world, and I think it's a right that we need to guard jealously. And in this case, the trial court diluted the reasonable doubt standard, and I think my client should receive a new trial. And I'm happy to answer any more questions the court has.
Thank you, Mr. Doman. Are there additional questions for Mr. Doman? I don't see any. Thank you both for your presentations. The case will be submitted and we will recess until 1 o'clock. Thanks all.